Your Honour, if it pleases the Court, my name is Freeman initial M and I appear for the defendants Mr. George White and Mrs. Fran White. Your Honour, at common law, a mistake may operate to negative or nullify contractual assent. There is a proposition that a contract is void if one party to the contract enters into it under a serious mistake as to the content or existence of a fundamental term and the other party has knowledge of that mistake. It is our submission that an injunction should be granted in order to prevent the plaintiff, Bank Limited, from selling the defendant's house. Your Honour, a mistake may be operative when it is made by one or both parties prior to or at the time the contract is formed. According to the facts, the defendant's son, Mr. Rob White, was a real estate developer. Mr. Rob White's company faced a downturn due to consumer resistance. This ultimately led Mr. Rob White to approach the plaintiff, Bank Limited, in order to acquire a loan to assist his company through its liquidity issues. The loan amounted to a sum of $2 million and provided for a repayment structure over 10 years. Bank Limited approved this loan, however, as a contingency, Bank Limited required security beyond the resources available to Mr. Rob White. In order to acquire the necessary security, Mr. Rob White approached his parents. In turn, and based on the statements and information provided by Mr. Rob White, the defendant signed the required documents. Bank Limited accepted this documentation as security and processed the loan for Mr. Rob White. Based on the information at hand, there has been a definite mistake in the formation of the contract. Your Honour, counsel for the defendants argue there is an evident case of unilateral mistake. A unilateral mistake occurs where only one of the parties is mistaken and the other party knows or ought to know of the mistake. Under the circumstances, counsel for the defendants requests the intervention of equity. Your Honour, if there are sufficient grounds to support a case of unilateral mistake, equity may set aside the contract or treat the contract as voidable. This is supported by the 1872 case of Torrance and Bolton, which provided equity will set aside the contract in a case of unilateral mistake whereby the courts find it is unconscientious for a party to avail their position of the legal advantage they have obtained by virtue of the contract. Counsel for the defendants refer to the case of Taylor and Johnson, reported in 1983, volume 151 of the Commonwealth Law Reports, page 422, where it was held that three particular elements must be sufficiently satisfied in order for equity to render a contract voidable. These include: 1. A party enters into a written contract under a serious mistake about its contents in relation to a fundamental term. 2. The other party is aware or has reason to be aware that circumstances exist that indicate the first party is entering the contract under some serious mistake or misapprehension. And 3. The other party deliberately sets out to ensure that the first party does not become aware of the existence of his or her mistake or misapprehension. Your Honour, counsel for the defendants argue all of these elements have been satisfied. The defendants entered a written contract under a serious mistake about its contents in relation to a fundamental term. The facts of this case indicate Mr. Rob White took the required documentation home and lied to the defendants. The defendants were misinformed in relation to both the duration and amount of the loan. As such, the defendants were under a serious mistake or misapprehension at the time of entering the contract. It is evident that Mr. Rob White deliberately set out to ensure that the defendants did not become aware of the existence of their mistake or misapprehension. Misrepresentation is defined as a false statement of past or existing fact made by the representor to the representee at or before the contract was entered into, which induced and was intended to induce the contract. These elements are all present. Mr. Rob White made false statements which induced my clients into entering the contract. The false statements made by Mr. Rob White were made prior to my clients entering the contract. Mr. Rob White has made a fraudulent misrepresentation. As stated in Derry and Peake, 1889, a statement will be fraudulent where a false representation has been made knowingly or without belief in its truth, or recklessly careless whether it be true or false, with the intention that it should be acted upon by another party who was thereby induced to act upon it. This is furthermore supported by the case of Alardi and Kruger, reported in 1955, volume 94 of the Commonwealth Law Reports, page 216, and Gould and Vargalis, reported in 1985, volume 157 of the Commonwealth Law Reports, page 215, where the most readily detectable type of fraudulent misrepresentation will occur where the statement maker is aware of the dishonesty of his or her statement. Mr. Rob White purposefully lied to the defendants and was well aware of his dishonesty. The defendants are entitled to either affirm or rescind the contract upon discovery of the misrepresentation. The defendants only became aware of the misrepresentation upon receipt of the notice from Bank Limited indicating to the sale of their home as a result of the default. Your Honour, the defendants are ultimately electing to rescind the contract. Your Honour, Bank Limited accepted the security, however Bank Limited failed to validate the contract. Bank Limited failed in their duty to ensure the defendants were fully capable of understanding the terms of the contract and the requirements of the security. If Bank Limited had acted with due diligence, they would have realised the defendants lacked capacity at the time the contract was formed. Your Honour, my client, Mr. George White, has a lower than average IQ. As such, he relies upon his wife to handle their finances. At the time my clients entered this contract, Mrs. Fran White had suffered a stroke and was also preoccupied with caring for another family member suffering from dementia. Counsel for the defendants requests these factors be taken into consideration. The defendants were incapable of understanding the nature of the contract. As was espoused by the High Court in Gibbons and Wright, reported in 1954, volume 91 of the Commonwealth Law Reports, page 423, the mental capacity required by the law may be described as the capacity to understand the nature of the transaction when it is explained. It is unknown if the defendants would have had the capacity to understand the nature of the contract, as Bank Limited failed to explain or validate the transaction prior to approving and processing the loan. Furthermore, it is our submission, as per Section 18 of the Australian Consumer Law, that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. Your Honour, there are definite aspects of unconscionable conduct based on contractual capacity, unilateral mistake, and deceptive and misleading conduct. With reference to Commercial Bank of Australia Limited and Amadio, reported in 1983, volume 151 of the Commonwealth Law Reports, page 447, unconscionable conduct was defined as being a ground of relief whenever one party, by reason of some condition or circumstance, is placed at a special disadvantage vis-a-vis another, and unfair or unconscientious advantage is taken of the opportunity thereby created. In Commercial Bank of Australia Limited and Amadio, the High Court held that it was prima facie unfair for the bank to procure the execution of the guarantee. It is our submission that the same decision be applied in the present case. Mr. Rob White took the paperwork home. By doing so, Bank Limited acted through Mr. Rob White. As such, his actions were their actions and his knowledge was their knowledge. Bank Limited failed to confirm the terms of the contracts with my clients, and my clients otherwise received no independent advice regarding the document. Your Honour, given the circumstances, it is prima facie unfair and unconscientious of Bank Limited to proceed to procure the signatures of the defendants as security. With reference to Commercial Bank of Australia Limited and Amadio, Bank Limited are also guilty of unconscionable conduct by entering into the contract without disclosing such facts. As per the decision in Commercial Bank of Australia Limited and Amadio, counsel for the defendants request the contract be deemed voidable and set aside. In conclusion, there are evident grounds for the defendants to rescind the contract. The elements of mistake, misrepresentation, and unconscionable conduct are all present. The defendants entered a written contract under a serious mistake about its contents in relation to a fundamental term. The defendants were ultimately induced into entering the contract based on false statements. There has been no consensus ad idem between the parties. As such, Your Honour, it is the defendant's request that an injunction be granted. The contract should be deemed voidable, or alternatively, the defendant should be entitled to elect to rescind the contract in order to be restored to their pre-contractual positions.